In March, Justice Thomas issued a statement in connection with the denial of certiorari by the Supreme Court in a case called Leonard versus Texas. In that statement, he suggested that modern civil asset forfeiture practices may be unconstitutional, at least cast some doubt on the constitutionality of those procedures as used by the federal government and many state governments. In May of this year, I wrote a letter to you asking whether the department would review its civil asset forfeiture policies and practices. In July, you announced some new policies that expanded the Department of Justice's use of civil asset forfeiture. Can you tell me whether you have asked the Office of Legal Counsel or any other component of the Department of Justice to provide a formal review of civil asset forfeiture practices of the federal government, of the states, and particularly the states and localities that participate in the equitable sharing program with the Department of Justice?
We had an intense series of discussions in the department about this subject. It's one that I'm familiar with, having served 12 years as United States Attorney myself and having utilized this policy. The policy was changed by the former Attorney General and constricted the ability of asset forfeiture in a number of ways. I simply restored the previous policy. The change only occurred 2 or 3 years ago. I believe it's the best policy, but I'm aware of the serious concerns you have and others have. I have constricted and placed some limits on how we do these forfeitures, and I have just announced the appointment of a special director of accountability to be in charge of all of the forfeitures in the United States, to review them, to review any complaints that arise. We want to carry out this policy effectively and fairly without abusing anybody's rights. I would note that for decades it's been affirmed by the Supreme Court. I don't believe there are votes on the Supreme Court that would declare it somehow now not legal, and we want to do it right.
I'm not sure that's clear one way or another. I mean, I understand your position, but I think there is some lack of clarity on this, and I think the statement issued by Justice Thomas in connection with the denial of certiorari in Leonard versus Texas does cast some doubt on it. But one of my questions is, hey, have you asked the Office of Legal Counsel for an opinion on this?
We're simply restoring the law that's been in effect for decades, and I don't know that we've asked a formal opinion of the Office of Legal Counsel, and don't think it's necessary to do so.
Okay. As you know, the reason I'm concerned about this is because in our criminal justice system in the United States, we have robust protections for the accused. You're entitled to a jury trial, to court-appointed counsel. You have a lot of due process protections as someone accused in this country. If the courts can circumvent those rights, at least with respect to the property of an accused, or to the property of somebody who may not himself or herself even be accused of a crime, but just as to which there is some suspicion about the involvement in the property, that presents significant concerns. If the government can just seize the property and then make it the government's property rather than that of the owner, such that it reverses the presumption of innocence, it reverses the burden of proof, and eliminates the requirement that proof of a crime be proven beyond a reasonable doubt. That's a concern. It's especially a concern where some states and local governments have adopted legislation restricting the use of this, and it's been then circumvented with the help of the federal government through this equitable sharing program. I do believe it needs to be reviewed and reviewed aggressively. Thank you, Mr. Attorney General.
Briefly, Mr. Chairman, a number of years ago, almost maybe 10 years ago, Senator Schumer, when he was a member of this committee, and I reached an accord when these issues were being raised. We raised the burden of proof, so a seizure of assets, often cash, those seizures cannot be effected without probable cause to believe it's either a product of the drug or criminal activity or a facility used to facilitate a criminal activity. And then if the person who had the money contests the case, they would have to, the government has to prove it on a preponderance of the evidence, which is a normal civil standard in a civil lawsuit. And the probable cause standard, you can arrest an individual, a grand jury returns indictments on probable cause. So it meets the same standard, really, that it would take to put somebody in jail. So I think it's a sound policy. 80% of the seizures are not even contested when DEA, the Drug Enforcement Administration, sets up a procedure for claimants to make their claim. And I believe it's a sound policy. But we'll continue to monitor it. I'm going to watch it even closer than we have before, and I would be pleased to stay in communication with you and hear your concerns.